Right, so we're now going to have a look around the criminal liability issues concerning the use of Taser. Now, a Taser is just a brand name and it's actually called a conductive energy device. So there's 4 cases here that we're going to look at. The first one's from Canada in 2007, but it's going to indicate as well how lengthy the process can be in relation to investigations and ultimately a decision for criminal prosecution. So if we look about how often tasers are used, then in England and Wales, the statistics for this, in 2009, it was used 3,128. In 2013, that's jumped to over 10,000 uses. And in 2016, that's jumped to 11,294 uses. And then looking at the percentage, about 17% it was actually discharged, and 51% of uses accounted for red dotting. Between 2004 and 2011, 11 deaths connected to Taser were reported to the IOPC, previous name the IPCC. Now, if we look at the Canadian case then, because this sort of sets the scene for when we jump to the 4th case to look at what's happening in this country now. So we have a 40-year-old in Canada who was tasered by the mounted police, so the RCMP. He was tasered multiple times at Vancouver Airport in 2007 after 4 officers responded to reports of a man throwing furniture. The constable who fired the taser that night, when the man died at the Vancouver International Airport, had been sentenced to 30 months in prison for perjury and colluding with his fellow officers at an inquiry into the death. The incident occurred in October 2007. It was reported when he ignored orders to calm down, police used a stun gun stroke taser. The man then dropped to the floor and police said it took 3 officers to handcuff him. He then lost consciousness and appeared to go into cardiac arrest and was pronounced dead at the airport. Now, CBC News reported Taser devices are controversial because of the dozen North American deaths resulting from their use. So let's have a look a little bit at this incident. The final inquiry report was released in 2010, in June of 2010, and it concluded that the police officers were not justified in using a taser against him, and that the officers later deliberately misrepresented their actions to the investigators. There's a link there to the YouTube footage, which has been posted by the Vancouver Sun News of the incident. So if you want to watch the actual footage, then go to that YouTube link and you'll be able to see it. Now, it then took until 2013, March of 2013, for the coroner inquest to rule on cause of death. And the cause of death was declared as cardiac arrhythmia due to, or as a consequence of, physical altercation in combination with multiple deployments of a conductive energy weapon, so the taser. He was tasered multiple times and subsequently restrained by the officers. It was declared a homicide. Now, the coroner report, some extracts here from that, just concluding there that the conclusion was he died of cardiac arrhythmia, which occurred minutes after being subjected to the deployment of a conducted energy weapon 5 times, and an accompanying physical altercation with police. The police officers deployed the energy weapon within 30 seconds from the time when one of the officers attending the scene first spoke to him. So again, you can see that on that YouTube video. Ultimately deploying the weapon 5 times, he was then restrained and handcuffed. Within seconds of being handcuffed to the rear, he lay motionless on the floor and was breathing heavily. He soon became unconscious and it was apparent he was experiencing significant medical distress. The police officers did not engage in any resuscitation efforts, but requested an ambulance being dispatched. So at this point, he's gone into medical emergency, but the police officers don't release him from the handcuffs and don't commence any CPR or any other attempts to save his life. When Richmond Fire Rescue staff first arrived, he was laying in the prone position, so that's face down, with his hands handcuffed behind his back. In order to assist in assessing his condition, the police officers were requested to remove the handcuffs, but they declined to remove the handcuffs. Next, the paramedics arrived about 90 seconds after the fire rescue staff arrived, and they further requested the removal of the handcuffs. It was only after the second request that the handcuffs were actually removed. The members of the fire rescue and the paramedics attempted various resuscitation measures for approximately 20 minutes, after which efforts were discontinued based upon a telephone consultation with a doctor, and he was pronounced dead at the scene. Now, in 2007, the government of British Columbia announced the commitment to hold a commission of inquiry into the circumstances surrounding the death. Following the death, the Integrated Homicide Investigation Team of the police commenced an investigation into the circumstances surrounding the death to consider whether criminal charges against any of the police officers were warranted. The autopsy showed no significant injuries and no natural disease process that would have likely led to sudden death. The pathologist concluded that the most likely cause of death was cardiac death during restraint. Numerous medical specialists, including forensic pathologists, cardiologists, emergency room physicians, as well as electrical engineers, provided testimony at the Braidwood inquiry. On the basis of their expertise, the finding of Mr. Justice Bracewood said that he died as a result of cardiac arrhythmia. It was also found that both the multiple deployments of the taser, along with the physical altercation, contributed to the circumstances leading to the fatal arrhythmia. Now, looking at the conclusion then, just to remind ourselves, it was classed as a homicide in Canada, whereas it says there, homicide is a death due to an injury intentionally inflicted by the action of another person. But homicide is a neutral term that does not imply fault or blame. So it certainly wasn't put down as accidental, it was down as homicide. And it ended up with the officer who drew the taser and fired the taser going to prison, but that was in relation to perjury rather than the killing. So let's come to England and Wales now, and we've got 3 examples here just as a timeline. So, death of Jordan Begley, Mr. Jordan Begley, in Manchester in 2013. So let's have a look at what happened with this case. So Jordan Begley, 23 years old, died after Greater Manchester police officers tasered and restrained him in 2003. The IOPC, so that's the Independent Office for Police Conduct, they said that there was evidence the officer involved used excessive force. An original report by the organisation into Mr. Begley's death, which found no individual officer had a case to answer, was quashed by the High Court in 2016 after it was found to be inconsistent with a subsequent inquest. The inquest jury believed that one officer inappropriately used the taser. From the IOPC report, they state, at 8:16 p.m. on the 10th of July 2013, Mr. Jordan Begley's mother, Mrs. Dorothy Begley, called 999 to request police assistance at her address in Gorton, Manchester. She stated that neighbours had accused Mr. Begley of stealing and that he wanted to go out fighting. She stated that he was in possession of a knife. So a number of officers attended in response to that call. According to those present, Mr. Begley was outside in the street when the first of the officers arrived, but subsequently accompanied some of those officers indoors. The officers who were inside the address for Mr. Begley stated that he became angry and shouted at officers to leave, and then approached PCD. PCD then discharged his taser, and Mr. Begley was taken to the ground and restrained. PCM delivered 2 distraction strikes before officers handcuffed Mr. Begley to the rear. The officer stated that Mr. Begley quickly became unwell and appeared to be struggling to breathe. They requested an ambulance, and Mr. Begley was taken to Manchester Royal Infirmary. He was pronounced deceased at 10 p.m. on the 10th of July 2013. The matter first came to the attention of the IOPC the next day on the 11th of July 2013 as a death or serious injury referral. At that time, the IOPC decided to carry out an independent investigation. Having reviewed the evidence, the lead investigator considered that there was an indication that some of the intending officers may have committed a criminal offence and/or behaved in a manner that would justify the bringing of disciplinary proceedings. As a result, the investigation was reclassified as a conduct investigation. On the 23rd of April 2014, so nearly a year later, the IOPC concluded that none of the attending officers had a case to answer for misconduct or gross misconduct. Then, over a year later, in July of 2015, an inquest was held into Mr. Begley's death. The jury at the inquest criticised the use of force by attending officers and concluded that the taser discharge and subsequent restraint had contributed to Mr. Begley's death. So in light of the inquest findings, the IOPC undertook a review of the initial investigation and decided to apply to the High Court to quash its own decision. The application was approved on the 25th of November 2016, and the IOPC then carried out a re-investigation in relation to the incident. So extracts from their report: it's been determined that the circumstances of this case potentially engage Article 2 of the European Convention on Human Rights, so EHCR. Because of the circumstances of Mr. Begley's death, Article 2 states that, with certain limited exceptions, everyone's right to life shall be protected by law and no one shall be deprived of his life intentionally. The state has a duty to investigate cases where it appears that Article 2 may be engaged, and to ensure, as far as possible, that the investigation is independent, effective, open and prompt, and that the full facts are brought to light and any lessons learned. The investigation is intended to assist in fulfilling the state's investigative obligations under the ECHR. A post-mortem examination was conducted on the 11th of July 2013. Mr. Begley had a number of facial injuries, including bruising to his left eye, described as a black eye, a number of marks around his forehead, marked bruising and swelling to his right upper eyelid, an abrasion at the lateral end of his right eyebrow, and purple bruising with a distinct stippled and striped appearance above his right eyebrow. He had 2 deep bruises below his right shoulder blade, which were not visible on the surface of the skin. Mr. Begley's blood alcohol level was nearly 3.25 times the current legal drink-drive limit in England and Wales. Post-mortem examination revealed numerous injuries, none of which of themselves were actually life-threatening. There was some minor injury to the wrists, commensurate with the history of handcuffs being applied. The bruising to the arms is compatible with the reported attempts to extract his arms from beneath him, whilst police officers tried to apply the handcuffs. The bruising to the back, shoulder area could have been caused by the 2 distraction blows struck by an officer in an attempt to extract Jordan Begley's right arm. The injuries to the right side of his face are obvious carpet burns caused by the carpet abrading his face when he lay on the floor during the attempted arrest. In other words, the injuries here are, in my opinion, in keeping with the history provided by the attending police officers. As previously stated, I emphasise that none of these injuries has contributed to the death. Okay, so that was from the post-mortem. What was also stated was, what are not present in Jordan Begley's case are injuries which might indicate a prolonged and violent struggle or a period of prolonged restraint. Of additional importance is the fact that there are no asphyxial signs such as facial congestion, small areas of the bleeding caused by the congestion in the head and neck when venous returns to the heart is disrupted, cyanosis. Asphyxial signs are common finding where there is significant and prolonged compression of the chest and or neck, and therefore may be found in cases of restraint where the chest has been compressed or there's been compression of the neck. I readily accept that the prolonged resuscitation might have masked some asphyxial signs, but I would be very surprised if all would disappear if they had initially been present. In terms of determining the precise cause of death, this I am not able to do since the pathological evidence does not provide me with a definitive structural cause of death. Based on all of the available pathological evidence, both positive and negative, and also on all of the information made available to me, in my opinion, the most likely cause of Jordan Begley's collapse and subsequent death was the development of a stress-induced cardiac dysrhythmia, which occurred at the culmination of a long and stressful series of events. Since I cannot prove or disprove that a cardiac dysrhythmia occurred on the basis of visible pathology, this must represent a diagnosis by exclusion, and I offer it on the balance of probability. Therefore, in strict pathological terms, the cause of death should, in my view, be certified as unascertained. Now, Taser, as we mentioned earlier, is a conducted energy device known as CED, approved for use by the UK police forces. The model used in this case was known as an X26. When Taser is fired, a barbed projectiles are propelled towards the target, so the person. The copper wires channel an electrical current from the device to the projectiles with the aim of completing a circuit through the intended target. If both barbs attach to the target's skin or clothing correctly with sufficient spread, the effects are likely to be instantaneous. People who are tasered usually experience some loss of voluntary muscle control accompanied by involuntary muscle contraction. This is referred to as neuromuscular incapacitation, or NMI. The device will cycle for 5 seconds if uninterrupted, but the user can interrupt this cycle at any point by activating the safety switch. Alternatively, the user can extend the 5-second cycle by maintaining pressure on the trigger. Statement from the IOPC: we examined the actions of 6 Greater Manchester police officers, and my view is that one former officer may have breached the professional standards of behaviour in relation to their use of force, but the officer had resigned. So following the death, the initial IOPC investigation concluded there was no case to answer from any officer. The jury found that there was cases to answer. So the IOPC reinvestigated and then concluded there was a case to answer, but the officer who they believed had a case to answer had now resigned, and therefore it was not proceeded with. So the next death in the same year is the death of Mr. Andrew Pimlott, which was in Plymouth. So circumstances around this event then. The inquest heard how 32-year-old Andrew Pimlott had doused himself in petrol before a police officer fired a taser at him. A fire erupted, engulfing Mr. Pimlott in flames. He died a few days later from complications from the burn injuries that he sustained. The jury returned a narrative verdict saying they felt the taser was the most likely source of ignition. A police spokesperson was reported as saying, whilst the outcome of the inquest in 2015 did indicate that the taser was the most likely cause of the ignition, no criticism was levied at the force or the officer, and confirmed the officer had used his taser in accordance with national training. Now, in October of 2015, the Independent Police Complaints Commission, so the IPCC, recommended that the National Police Chiefs Council and the College of Policing revise their taser training in order to provide a more comprehensive guide to officers when dealing with flammable liquids. The IPCC makes clear that following this incident, tasers should only be considered for use in the presence of flammable substances as a last resort, and after every other available option has been considered and discounted. The recommendation is included in the IPCC investigation report being published today that examines events including discharge of taser surrounding the death of Andrew Pimlott in April of 2013. Mr. Pimlott died after suffering severe burns, having doused himself in petrol. He was also tasered during the incident. The IPCC recommended, and Devon and Cornwall Police agreed, that an officer had a case to answer for gross misconduct for his actions. A misconduct panel held by Devon and Cornwall Police in March of 2015 found that the case against the police constable was not proven. At a HM coroner inquest in Plymouth, a narrative verdict was returned that found the taser was the most likely source of ignition. The IPCC Associate Commissioner Tom Milson said, "I hope today's inquest verdict brings some closure to Andrew's family following his death in April 2013. I know how deeply this has affected them. My thoughts are with them and others involved in this tragic incident." The IPCC conducted a full and thorough investigation into this death, culminating in a recommendation that the policing authorities review the use of taser in close proximity to flammable liquids. Now, jumping forward then, so those two incidents were 2013, we go to a 2016 incident, which is current now. So in 2016, there was the death of Mr. Daly and Atkinson. Now, this has resulted in one officer being charged with murder and one officer being charged with assault ABH. So the incident occurred in 2016. Criminal charges were brought against the two officers in November of 2019. one officer charged with murder, one officer charged with ABH, and their trial is likely to commence on or around September of 2020. So that's just bringing about a summary in relation to Taser and the criminal liability of how things progress and the length of time that's involved from an incident occurring through various investigations and criminal charges to be considered.